often these days is simply a means to a political end. This, unfortunately, is an outgrowth of what we've seen over the last 20 or 30 years in legal education, known as critical legal studies, which is a neo-Marxist ideology born on college campuses, which also gave birth to what's now a controversial topic, critical race theory. So-called critical theories abandon reason for power. As such, law is merely a tool to effectuate outcomes. There's no right or wrong, just good or bad, and good's not a moral concept, it's a personal preference. So predicting the constitutionality and legality of mandates, as I've been asked to do, becomes increasingly difficult because it's not a legal analysis, it's an exercise of politics. Objectively, we can say that the law permits mandates in certain circumstances and not in others, but that's not much of a statement at all. In the well-known case of Jacobson versus Massachusetts, the U.S. Supreme Court held that the state could fine those who didn't get a vaccine. Notably, the issue wasn't a forced vaccination, just whether those refusing could be financially penalized. So this case offers some support for the notion that under certain circumstances, courts have held that states can penalize those not complying with public health regulations. The Seventh Circuit, U.S. Court of Appeals, recently held that public universities could condition higher education on vaccine status. And in the private sector, of course, businesses are not bound by constitutional restrictions, they are bound by statutory prohibitions, such as Title VII. Private businesses are permitted to control the behavior of their employees so long as they don't violate statute, as Senator Garner pointed out. Of course, at-will status is not altered one way or the other by whether the legislature creates restrictions on the terms of employment. It doesn't restrict whether an employee is held at will or must be employed for a cause. So what can we do if we recognize, for example, that the actions of this legislature recently taken and overturned by Judge Fox were clearly constitutional? How do we address the lack of law in executive actions and judicial determinations these days? Well, here's what I'm doing. As a conservative, as a lawyer, as a law professor, I believe it's necessary to restore the authority of the legislature, to remove the anti-democratic interference of political activists in judicial robes. So I filed 2 cases so far seeking to have the will of the legislature enforced. Of course, these cases are filed in court, subjecting me to the possibility of drawing a political activist in a row. But I fully intend to litigate these cases up to the Supreme Court. Sure, the outcome is far from certain, but I will work within the system, and I hope that ultimately our Supreme Court, elected by the people of this great state, will do a better job than the limousine left holding court both literally and figuratively on West Market Street. The first case seeks to have the courts respect the law that this legislature enacted that permits lawyers as officers of courts to carry firearms in courthouses, Act 1087 of 2017. And the second case I filed yesterday seeks to have municipalities allow holders of enhanced concealed carry licenses carry their concealed firearms in city buildings, just like they may here at the Capitol, as guaranteed by the recently enacted Act 1024, written by Bob Allinger. It's high time that leftist judges in localities stop thumbing their noses at the Constitution of the state and the will of the people as expressed by the most democratic body, that is the legislature. In both of these cases, the plaintiff is freedom-loving Arkansas attorney Chris Corbin. Chris is in the gallery here today. You might have seen his mobile office driving around Conway or Little Rock. You probably heard him on the radio with me. And you will soon see him running for Senate from the Conway area. If elected, I imagine he would join the Judiciary Committee in defending the freedoms of Arkansans. The second way to address the underlying problem with the failure of contemporary courts to respect the law goes to the aforedescribed politicization of legal education across this country. At my law school, for example, no conservative has ever taught constitutional law. Indeed, when one of the two professors who taught constitutional law became the dean a few years back, rather than bringing in a diverse perspective, the school had the other professor who taught it teach both the day and night classes. That other professor, well known, perhaps best known for advocating in favor of Bill Clinton during the impeachment process. That second professor is now retiring, and I have long since volunteered to teach constitutional law, but the law school has refused that request. Indeed, should I actually be allowed to teach constitutional law, I would not only be the only conservative to ever have taught constitutional law at this law school, I'd be the only Jew. That's diversity, folks. You want diversity? That's diversity.